Welcome back to Doctor Not Guilty. This is Chapter 10, To Plea or Not to Plea. Today we are embarking on an exhaustive, deep exploration into one of the most critical, yet least understood mechanisms of the American legal machinery, the plea bargain, and how it is weaponized against healthcare providers, physicians, and citizens alike. In this episode, we will deconstruct the psychological, financial, and structural pressures that drive innocent people to admit to crimes they never committed. We will examine my own personal journey in late 2012 and 2013, the founding of Blue Mountain Psychiatry, and the high-stakes choices that defined my medical career. We will also analyze in meticulous detail the landmark federal prosecution of Dr. Ashish Rakit and Dr. Jayati Gupta Rakit, a case that serves as a masterclass in how to resist government overreach. Finally, we will examine the devastating, irreversible collateral consequences of a guilty plea on a medical license, DEA registration, and personal life, ending with actionable blueprints for systemic reform. To understand the fight for justice, one must first understand what is at stake and why an independent practice is worth protecting at all costs. By the close of 2012, I had reached a defining crossroads in my professional life. For years, I had navigated corporate medicine, hospital systems, and administrative bureaucracies. While those institutions serve a purpose, I increasingly felt that the administrative apparatus of modern healthcare was coming between the physician and the patient. Corporate mandates, bureaucratic interference, and algorithmic care models were eroding the sacred core of the doctor-patient relationship. I made a deliberate decision to embark on an independent path, one that would allow me to practice medicine purely on my own terms, driven by clinical judgment, scientific evidence, and uncompromised ethics. In December 2012, I founded Blue Mountain Psychiatry. The vision for Blue Mountain Psychiatry was clear from day one: to establish a regional center of excellence built on rigorous clinical ethics, evidence-based medicine, absolute scientific integrity, and genuine human compassion. We did not want to build just another routine outpatient clinic. We wanted to build an innovative practice that tackled the most complex, challenging psychiatric and medical cases in our community, individuals who had often been turned away or failed by traditional clinical settings. We envisioned a sanctuary where patients were treated as human beings with dignity rather than data points on a corporate spreadsheet. Because of that vision, we intentionally designed Blue Mountain Psychiatry as a forward-looking, advanced practice. Long before virtual care became widespread or normalized by global events, we embraced telepsychiatry as a vital modality to reach underserved rural populations across Pennsylvania who lacked access to psychiatric specialists. Furthermore, we integrated advanced, cutting-edge interventional modalities into our practice. We were early adopters of transcranial magnetic stimulation, or TMS, offering a non-invasive, highly effective treatment for severe treatment-resistant depression. We also established structured, medically supervised ketamine protocols for patients suffering from severe, persistent mood disorders who had exhausted all conventional psychopharmacological options. Innovation, however, often attracts scrutiny from traditionalists and regulators who do not understand modern medical advancements. Operating at the forefront of medical technology meant that our clinical protocols were meticulously documented and anchored in published, peer-reviewed literature. Yet, in the eyes of insurance auditors and federal investigators who rely on outdated billing frameworks, high-volume innovative care is often misconstrued. When a clinic invests heavily in specialized interventional therapies, it generates billing volume that sits outside standard statistical norms. Rather than recognizing this as clinical excellence and patient access, investigative algorithms flag it as suspicious activity. This fundamental disconnect between modern medical practice and bureaucratic compliance algorithms is where many healthcare prosecutions begin. While the clinic was growing rapidly, this period was equally monumental on a personal level. In January 2013, my wife and I welcomed our third son, Zaid, into the world. Holding a newborn child while launching a pioneering medical practice serves as a profound anchor. It reinforced to me that no matter how demanding the clinical work became, no matter how complex the healthcare environment grew, family, service, and my true calling as a healer remained the immovable center of my life. Building a legacy for my family meant standing firm in my principles, regardless of the winds blowing around me. Right during this period of expansion and family growth, executive healthcare recruiters approached me with an extraordinary offer. They presented a prestigious, top-tier medical leadership position in the Middle East, based in Qatar or the United Arab Emirates. The offer included an annual salary of $1.5 million, fully tax subsidized, complete with housing allowances, international school tuition for my children, and state-of-the-art institutional funding. For any physician, especially a young father building a practice, the prestige, global standing, and absolute financial security of such an offer were immense and undeniably compelling. Yet, after deep prayer, family reflection, and careful thought, I turned down the $1.5 million offer and chose to stay right here in Pennsylvania. That decision was never about turning away from financial prosperity or international prestige. It was about recognizing that my true purpose, my duty, and my calling were right here, serving patients in local communities who desperately needed high-quality psychiatric and medical care. Looking back, that choice demonstrated that my commitment to my patients and my ethical standards was never for sale. When you choose duty over easy paths, you prepare yourself for whatever trials lie ahead, including the legal battles that so many physicians unexpectedly face. Now, let us transition from my personal foundation to the broader, troubling reality of the American criminal justice system. When the average person thinks about criminal justice, they imagine what they see in movies: dramatic courtrooms, passionate closing arguments, impartial juries, and a trial where evidence is weighed fairly. But that Hollywood depiction is a complete fantasy. The modern American legal system is not a trial system. It is a plea bargaining system. Nationally, over 97% of all federal criminal convictions and over 94% of state convictions are resolved through plea agreements without ever reaching a jury trial. Less than 3% of accused individuals ever exercise their constitutional right to a trial by jury under the Sixth Amendment. This transformation of our legal system from a trial-based forum into an administrative clearance process has profound legal and ethical implications. The framers of the Constitution envisioned the jury trial as the ultimate check on governmental power, a safeguard ensuring that no citizen could be deprived of liberty without public presentation of proof beyond a reasonable doubt. Today, that constitutional check has been largely dismantled. Instead of proving guilt in open court, prosecutors leverage institutional advantages to negotiate outcomes in private offices, effectively shifting the locus of determination from neutral juries to executive branch attorneys. When administrative convenience and quick case clearance become the primary drivers of a justice system, the pressure brought to bear on defendants escalates to unbearable levels. In federal healthcare fraud, billing disputes, and medical practice investigations, this pressure becomes terrifyingly focused. Prosecutors hold an overwhelming advantage. They possess unlimited financial resources, teams of federal agents, investigator networks, and the power to freeze assets before a trial even begins. When a physician or healthcare provider is indicted, they are routinely faced with decades in prison and millions of dollars in potential fines. In that high-pressure environment, an offered plea bargain stops feeling like a voluntary choice and starts operating as psychological coercion. To truly grasp how this process plays out against dedicated medical professionals, we must examine a landmark case: the prosecution of Dr. Ashish Rakit and his wife, Dr. Jayati Gupta Rakit. Dr. Ashish Rakit was a respected, highly trained cardiologist practicing in Ohio. The government targeted his practice not because patients were harmed, not because medical outcomes were poor, but primarily because statistical algorithms flagged his practice as a high-volume billing outlier for diagnostic cardiac testing. The government launched a massive federal investigation, operating on the assumption that high-volume testing automatically equaled fraudulent billing and medically unnecessary procedures. As part of their aggressive investigation, federal law enforcement deployed confidential informants and undercover agents equipped with hidden body wires into Dr. Rakit's clinic. These undercover operatives posed as genuine patients complaining of chest pain, shortness of breath, and cardiovascular symptoms. The government attempted to construct a prepackaged narrative, claiming that Dr. Rakit was ordering nuclear stress tests, echocardiograms, and cardiac catheterizations that were medically unnecessary, and that he was systematically overbilling federal healthcare programs like Medicare and Medicaid. What the government failed to appreciate was the nature of clinical cardiology. When a patient presents with cardiac risk factors, atypical chest pain, or shortness of breath, standard of care guidelines dictate thorough, comprehensive diagnostic evaluation. Omitting diagnostic testing in a high-risk cardiac patient can result in missed diagnoses, sudden cardiac death, or severe ischemic events. Dr. Rakit's clinical decisions were driven by patient safety and medical protocol, yet federal agents interpreted comprehensive diagnostic care through the narrow clinical distorting lens of financial fraud. When Dr. Rakit asserted his innocence and refused to plead guilty early in the process, the prosecution escalated their tactics, a strategy known in federal practice as superseding indictments. The initial indictment contained 24 counts. But as the defense prepared to fight, the grand jury returned a superseding indictment, expanding the charges to 87 individual felony counts, including healthcare fraud, false statements, and conspiracy. By multiplying the counts, the prosecution increased Dr. Rakit's theoretical prison exposure to hundreds of years. This systematic stacking of charges is designed for one primary goal: to crush the defendant's resolve and force a guilty plea before trial. Despite facing catastrophic potential prison sentences, financial ruin, and intense public scrutiny, Dr. Ashish Rakit and Dr. Jayati Gupta Rakit refused to capitulate. They made the brave, extraordinary choice to decline all plea offers and demand their day in court. They took their case to a federal jury trial that lasted 10 long, exhausting weeks. The government called over 45 witnesses, introduced thousands of pages of medical charts, and played extensive secret audio recordings recorded by undercover agents in the clinic. The trial was a grueling battle of endurance, resources, and legal strategy. The defense team, through brilliant cross-examination, focused heavily on exposing the deceptive nature of the government's investigation and dismantling the credibility of their informants. They demonstrated to the jury that the undercover agents had intentionally exaggerated symptoms while on wiretaps, creating clinical scenarios where any competent, prudent cardiologist would order diagnostic testing to protect the patient's life. The defense systematically established a core truth: if you cannot trust the credibility of the messenger, you cannot trust the integrity of the message. They proved that Dr. Rakit was practicing defensive, thorough medicine to save lives, not to commit fraud. The defense strategy delivered a historic result. After days of deliberation following the 10-week trial, the federal jury returned not guilty verdicts on 50 separate felony counts and completely deadlocked on the remaining 37 counts. The government achieved 0 convictions. The Rakit case stands as a monumental triumph of justice, proving that government allegations are not absolute truth and that when doctors stand firm against coercive pressure, the truth can prevail. But how many doctors have the financial, emotional, and physical capability to survive a 10-week federal trial? Very few. The Rocket case forces us to ask a fundamental ethical and legal question. When investigators craft artificial narratives, deploy undercover operatives to falsify clinical complaints, and stack dozens of felony counts to threaten a defendant with life in prison, can any resulting plea bargain truly be considered voluntary? When a plea is negotiated under the threat of total personal and financial destruction, it is not a free exercise of choice. It is a contractual surrender under duress. To those outside the legal system, it remains a baffling paradox. Why would an innocent person ever agree to sign a document admitting to a crime they did not commit? To an outsider, it sounds illogical. But inside the criminal justice system, innocence is often a secondary concern compared to risk management. Innocent people plead guilty every day because of fear, overwhelming psychological pressure, crushing legal costs, uncertainty, and basic human survival instinct. When faced with a choice between a guaranteed light sentence and a potential 30-year prison term if a jury makes a mistake, rationality shifts completely. Consider first the brutal reality of pretrial detention. In many state and federal cases, defendants are denied bail or given exorbitant bond amounts that they cannot afford, especially after their bank accounts are frozen by government asset forfeiture motions. An accused person who is locked in a detention center while waiting for trial may spend 12, 18, or 24 months in jail before ever seeing a jury. If a prosecutor offers a plea deal that includes time served or immediate probation, the innocent defendant is presented with a choice: stay in jail for another year, fighting for innocence, or sign a piece of paper today and walk out the door to see their children tonight. Under those conditions, freedom today outweighs absolute vindication tomorrow. Another critical driver of coerced pleas is what criminologists and legal scholars call the trial penalty. The trial penalty refers to the dramatic disparity between the sentence offered in a plea deal and the sentence imposed if the defendant goes to trial and is convicted. In the federal system, judges routinely impose sentences that are 3, 4, or even 5 times longer after a trial conviction than what was offered in pre-trial plea negotiations. Prosecutors openly use the trial penalty to penalize defendants for exercising their Sixth Amendment rights, creating an environment where taking a case to trial is treated as a high-stakes gamble with a person's entire remaining life. This risk is further amplified by prosecutorial overcharging. Prosecutors frequently bring multi-count indictments, charging dozens of overlapping violations for what is essentially a single dispute over medical billing or documentation. A physician charged with 50 counts of healthcare fraud faces a theoretical exposure of 500 years in prison. When the prosecutor offers to drop 49 counts if the physician pleads guilty to just one count of making a false statement with a recommendation for probation, the sheer mathematical math forces even the most principled, innocent doctor to give serious consideration to the deal. Compounding this structural imbalance is the widespread issue of legal representation and defense costs. Defending a complex federal healthcare case requires specialized legal counsel, expert medical witnesses, billing auditors, and millions of dollars in legal fees. Many physicians find their defense funds exhausted long before trial begins. Furthermore, in broader criminal courts, public defenders and overworked defense attorneys are forced to handle hundreds of active cases simultaneously. They simply do not have the time, staff, or forensic resources to conduct independent investigations. In those circumstances, defense attorneys often advise clients to accept a plea bargain, not because the client is guilty, but because fighting the charge seems legally impossible. Tactical manipulation and psychological pressure also play a central role in driving guilty pleas. Prosecutors often impose exploding plea offers, telling defendants that an offer is only valid for 48 hours and will be permanently withdrawn if not accepted immediately. Furthermore, prosecutors may threaten to indict family members, business partners, or medical colleagues who worked in the same practice, using loved ones as emotional leverage. Facing the threat of seeing a spouse or child drawn into a federal investigation, an innocent individual will willingly sacrifice themselves and accept a felony plea just to shield their family from harm. When an innocent person is subjected to relentless public humiliation, asset seizure, media leaks, isolation, and the looming threat of spending decades in a federal penitentiary, psychological breakdown occurs. The human mind can only endure so much sustained stress. Under total psychological desperation, signing a plea agreement becomes an act of self-preservation, a way to stop the relentless legal machine from grinding one's life into dust. Regrettably, accepting a plea deal almost always requires waiving the future. Standard federal plea agreements contain sweeping appeal waivers, where the defendant surrenders their right to appeal the conviction, challenge the sentence, or assert post-conviction claims of ineffective assistance of counsel or newly discovered evidence. In many cases, defendants are even required to sign statements affirming that they are fully satisfied with their legal representation and that no coercion took place. In doing so, the defendant effectively locks the door to their own cage, making future legal redemption nearly impossible. The ultimate price of a guilty plea extends far beyond the immediate courtroom proceedings or probation terms. A felony conviction creates a permanent criminal record that permanently alters an individual's civic, personal, and professional identity. It impacts housing opportunities, credit eligibility, voting rights, firearm ownership, and community standing. The societal stigma of a criminal record persists long after any financial penalty or sentence is completed, serving as a life sentence of secondary disadvantage. For medical doctors and licensed healthcare professionals, these collateral consequences are absolute and career-ending. A single felony plea, or even a misdemeanor plea involving healthcare billing, triggers automatic mandatory exclusion from federal healthcare programs under the Office of Inspector General for a minimum of 5 years, and often permanently. It leads to the immediate loss or surrender of state medical licenses, the revocation of DEA-controlled substance registrations, expulsion from hospital medical staffs, cancellation of commercial insurance provider contracts, and total destruction of a medical career built over decades of dedicated sacrifice. A doctor who pleads guilty to save themselves from prison often finds that their identity as a healer has been completely erased. Long after court proceedings end, the conviction remains an indelible mark. In the federal legal system, expungement of criminal convictions is practically non-existent, regardless of post-conviction rehabilitation or exemplary community service. The permanent stain impacts global travel, international professional licensing, immigration status, and family security for decades. The legal system claims that a plea agreement brings finality, but for the falsely accused professional, it brings a lifetime of ongoing loss. If we are to restore integrity to our legal system and protect healthcare providers from overreach, we must implement meaningful structural safeguards that prevent innocent individuals from being coerced into plea deals. We must challenge the fundamental premise that a system resolving 97% of its cases through coerced agreements is functional or constitutional. True justice requires transparency, balance, and accountability at every stage of the investigative and judicial process. We must always remember that taking a plea bargain does not equal guilt. To correct this broken reality, we must enact comprehensive reforms. First, requiring full prosecutorial transparency and mandatory early disclosure of all exculpatory Brady evidence before any plea agreement can be offered. Second, establishing active judicial oversight to scrutinize plea deals and evaluate charge stacking. Third, capping the trial penalty so that defendants are not punished with massive sentence multipliers simply for going to trial. Fourth, expanding funding and forensic resources for public and private defense teams. And fifth, creating accessible pathways for post-conviction relief and actual innocence claims even when appeal waivers were signed under duress. In conclusion, every plea deal carries a profound human, professional, and ethical cost. When a system relies on pressure, fear, and overwhelming power to compel citizens into surrendering their rights, that system forfeits its moral authority. Sometimes the cost of a quick plea deal is not just administrative efficiency or procedural finality. Sometimes the cost is justice itself. Thank you for listening to Dr. Not Guilty, Chapter 10. Stay vigilant, stand firm in your truth, and join us next time as we continue to shine light on the intersection of medicine, law, and human rights.